Hello, everybody. Last week we looked at a little bit of the Pennsylvania Rules of Civil Procedure concerning pleadings, and Rule 1017 deals with those, and it gives you 4 options for pleadings. And first and foremost is a complaint and then an answer to the complaint. The complaint, of course, states the cause of action. An answer can deal with the facts of the complaint against you. It can deal with the legal sufficiency, whether it's a good claim against you. It can assert a claim back against the plaintiff that has sued you, or it can assert a cross-claim, which is a claim against another co-defendant. Think about this, everybody. For instance, with respect to the complaint, it alleges, say, that you went to the bar, that you punched somebody, that you were outrageous. The answer part of your case would respond to that. It would say, denied, I was never at the bar, or it would say, denied, I did not punch anyone, or denied, if I struck anyone, it was in self-defense. That would be an example of an answer. Now, we have new matter as well that can also be in an answer. New matter is really what we call an affirmative defense. And an affirmative defense means that if you can prove that, you will successfully defeat the claim. And there are a bunch of affirmative defenses, and there'll be a link in that in your session this week. There are probably 25 or 28 different affirmative defenses. And basically, if you can prove those, you'll defeat the claim that's against you. And can I give you a good example of new matter in the case of Butler versus McCoy? Yes, I can. Self-defense is one of the oldest affirmative defenses known. And basically, if you are being sued for having attacked someone, and you can show that you were not the aggressor and you were simply defending yourself, you're going to defeat that claim. Now, we'll spend some time talking about what different legal theories can serve as affirmative defenses, but that'll be in a little bit of time. You can also have a counterclaim. Everybody loves counterclaims. If Mr. Butler and Tamarcus Porter sue LaShawn McCoy and his friends, they may say, wait a minute, we didn't hit you, you hit us. So they can assert a claim back against the plaintiff. That's what a counterclaim is. Very common. Oftentimes in business, people have conflicting stories. In all sorts of things with law, people have conflicting stories. But the essence of it would be that you're making a claim back against the plaintiff. By the way, you may not know it, but you're very close to knowing how to do all of these already. A counterclaim is really just a complaint turned around and filed against a defendant. It could be a different cause of action. It could be something entirely separate from the original complaint, but it still is a valid claim back against the plaintiff. A cross-claim. Cross-claim is a claim against one of your co-defendants. Very possibly in the McCoy case, Mr. McCoy is there with 3 or 4 people in his party. He may say, if anybody finds anything wrong with anything I did, it wasn't my fault, but it was, and then name somebody else in his group. So you'd assert a cross-claim against that person. Basically what would happen is you would file that, and what the plaintiff would do is they would have to file a reply to the new matter or the counterclaim or the cross-claim. So the reply would simply say, we deny the fact that self-defense is valid in this case, or whatever the cause of action is. But a reply responds just to the new matter, counterclaim, or cross-claim. If you send a reply in that raises another defense against their claim of the counterclaim, then again you do a counter reply. We'll track this down. Don't worry, everybody. I even think it's a little confusing. But the part that gets really good is when you get to number 4 and you realize what a preliminary objection can do. A preliminary objection is just that. It's preliminary. You don't want to respond to the pleading that's been served upon you because you think something is wrong with the pleading that has been served upon you. Could be a complaint, could be a counterclaim, could be a cross-claim. You can file a preliminary objection as to any pleading. So what the preliminary objection does is it sort of this is the timeout sign, everybody. So it says timeout. We want to challenge this before we move ahead and file an answer or a reply to the counterclaim or a reply to the cross-claim. We think there's something wrong with your pleading. So you can file a preliminary objection, for instance, to a complaint and say any number of things. You can say there's not a valid claim here. You can say it's been filed in the wrong place. You can say nothing was served properly on these parties. You can say that there are also other flaws with the pleading itself. Once in a while, you'll get not enough information. You can file a preliminary objection to that and say this is too vague to answer. You need to provide more information. And what will happen is eventually that will get to a judge, and a judge will either overrule your preliminary objections or they will sustain them. If they sustain them, your claim is you are right. Your preliminary objection is right. You may be able to throw out the complaint. You may be able to force them to have to fix their complaint. If the court overrules your preliminary objections, it says your preliminary objections are no good. You're still okay because by filing a preliminary objection, you get more time. Once the court rules on the preliminary objections, you're still going to have time to answer. So it's kind of a valid little device to be able to file. And we'll spend a little time talking about those, and we'll spend some time talking more about answers this week. But that's the story for now, everybody, and I will see you soon.